Hi, everybody, and welcome to contract negotiation, closing the quarter strong. My name's Tim. I'm the Chief Legal Officer here at LinkSquares, and with me I have Ashlyn Donohue, and we're going to walk through some charts. So, um, happy to invite you all to ask any questions through the chat here. We'll do our best to keep an eye on it, and I know some of our team here will send us slacks if we somehow are not recognizing that things are coming through in the chat. So, Ashlyn, you want to say hi?
Yeah, hi, my name is Ashlyn Donohue. I'm the Director of Legal here at LinkSquares, and super excited to talk about closing the quarter strong.
All right, well let's get it started here. All right, so we'll go through sort of mindset and style first, and then we'll talk a little bit about different provisions I think every lawyer should know, and then maybe go a little bit more in depth with some tactical negotiation tactics. So, Ashley, you wanna kick us off, and how do you get into that negotiation mindset, and what is sort of front of mind for you as you're maybe in the 5 minutes before jumping on a call with somebody?
Yeah, I think for me, when I'm thinking about negotiation mindset, I'm really thinking about partnership. Early on in my career, felt like this was like an adversary battle that we maybe had to like duke it out at the end of every quarter to get the deal done. That does not work. That is definitely not my style. So the 5 minutes before, I'm really thinking like, what is it that they care most about? What are they trying to get out of this call, and how can I come to the table prepared to find a resolution that's going to meet both of our team's needs in an acceptable manner? And so that's really what I'm trying to think about, is less about like, okay, I have this negotiation call and like we're going to be going head to head and trying to come down to some terms. It's more like, how can we work together to find the best deal for our teams so that they can get moving with whether that's the sale of a contract or the purchase of some tool they're super excited about.
Yeah, absolutely. And I think on my end, I also take a pretty um, business centric sort of collaborative approach to finding the right deal, right? Walking in there, I think is with that mindset that is, it's more than a transaction. It's the, continuation of a relationship that started between the sales folks, right? Sales folks and the purchaser. And really like, I would say too, like walking in prepared, like with a really good understanding of what you want to negotiate, what you can negotiate on, what you can't, and and sort of crafting your positions on those things in in a way that brings in the context of the broader business deal. Taking a few minutes to think about that. It's not just about a limitation of liability or an indemnification provision or whatever it may be, or even parts of the more substantive business points where you're able to say, okay, like it's not unlimited liability because I said so. It's this particular limit on the liability, given the size of the deal, given the likelihood of the risks and things like that. So I think a lot about that preparation side of it too before I really get moving on.
I think that's so important.
All right. And I know we touched a little bit on this, like, what are maybe some of the pitfalls that you see, and going in with the wrong mindset, and how can you start to recognize when maybe your mindset is shifting throughout the course of the negotiation?
Yeah, I think this is interesting, and I think, one of the things I think when you're coming to the call, like everyone's intentionally taking time to find a path forward and partner together, and you want to be mindful about how you approach things too. So it's like very much being prepared. What is it you're about to talk about? What can you give on? What can't you give on? But also thinking about like how are you going to convey that message in an impactful way that makes them feel like you're valuing their time and valuing their partnership. And one of the things I think folks can occasionally do is like a pitfall is come and give away all their cards like right off the bat. It's like, why are we on this call? You just literally said we're, not like we're good on everything, but it's like, I really wanted this, but I'll just give this to you and here's why, and like give all the positions. And I think that if you're taking the time to get on a call and you're pushing back on a point, you have to stand behind that. You have to have a why. You can have a, reasoning for giving on it eventually, but you can't just be like, yeah, sure, here you go. And I think that like if you get to that point where you do have a position that you need to really hold firm on and like you don't have wiggle room, it makes it a lot harder if it's like you've just been carte blanche, like I'm not giving you any context on why I kept pushing back on this for like 5 rounds in, and I just gave it to you, but like this is the thing I'm going to die on a hill over. Like I think you need to find that balance to be successful.
Yeah, I think that's absolutely right. One of the other things that um, that for me like really changes the way that I approach a negotiation is whether the business folks are on the call or if it's just lawyers,
Yeah.
right? Um, Typically, if it's just lawyers, what I've found is that it's in a lot of cases it's actually harder to get the deal done, right? I mean, it's obviously like, for example, with us with like our customer contracts, it's a little different because like the purchaser is the lawyer, and but I think about like some of the different vendor agreements and some of those negotiations that you get into. Having the business stakeholder there with you on the call is important because sometimes that other party will say something or justify a point that they want with some pretty sound business reasons on their end, and you may not have the full context on how that could impact the deal for your stakeholder who actually wants this thing that you're getting. So that's how like I actually tend to do a lot more preparation on that side, and I found that failing to prepare with the business stakeholder if they're going to be on the call, there's nothing that like messes up my mindset more than like something not going as planned on a call. Like I'm just not a big fan of surprises, right? When it comes to negotiating deals. So
Well, I think it's so important because there's nothing worse than getting on a call and like digging in your heels and being like, this matters so much because we're, sharing all this really sensitive data with you. And they're like, our product, that's not what our product does. And it's like, oh, I didn't take the time to ask the right questions on my side. Like that business preparation too, to make sure you know the product you're selling really well or what you're buying. So you don't
right.
like that trips me up if I'm like, oh, wait a second, like I looked at this all wrong, like that. There's nothing worse than that.
Yeah, exactly. And I know Kristen on our team just put a CLE code in the chat. So for all of you who need the CLE credits, that's the first code, and then later on in the session we'll have the second code. So um, yeah, so um, let's get into style. So Ashlyn, what is your style when you go into these negotiations, and does it change depending on what you're negotiating?
It 100% changes. I think that my style generally is very friendly, um, transparent, partnership oriented. I think that there is definitely a shift though when you're coming at it from like a sell perspective and you're selling your product versus when you're buying something, particularly when it's a point that really matters and it is something that you're willing to walk away from the deal on. Like I might change my tone and be even more forceful and a little bit more like foot in the ground than I would on a customer deal. If it's with a vendor and I know that I have that flexibility and wiggle room, but I am not the person that's going to be getting really upset and yelling on the call. I like to have my camera on. Like I want to be friends at the end of this and maybe like get a coffee if you're in town. So I am not like coming in like this is a one and done deal. Like I really feel like our business teams are building relationships, but we're also building one too. And I do enjoy and have had coffee with folks and met up with folks that I've negotiated with because we met over a deal and like that's just the best feeling.
Yeah, yeah, exactly. And obviously a lot of our contracts here are with customers, so like having a super adversarial process during that is uh, probably not the best way to start off the relationship.
No.
Um, yeah, yeah, I mean my style tends to be pretty similar. Um, However, there have definitely been moments where I've taken a more aggressive approach. I think about think about a deal earlier in my career um, where we were purchasing a company, right? And so we're going through the deal docs, and the business person. So there was a business person and a lawyer on the other side, and then me and two of our, me and our CEO and our CFO on our side. And we had gone through probably like, I don't know, three or four separate phone calls, and we were down to a couple of final points, and I ended up like just basically like taking a really hard line approach. Is like, here's our position. If you want to sell your company to us, you're going to take it, and that's it. And I was like, Jason, if you disagree with this, then then say so. I'm like, but this is what's going on. And and they pushed back. It ended up being like 35 minutes as to why are we taking this position? And we told them, and they're like, well, this is unreasonable. And it's like, well, it doesn't matter how unreasonable you may think it is. This is our position, and we're going to, we're the ones writing the check, and you either want the money or you don't.
Yeah.
And so, when you get to a particular point, the good thing about it was that the business person on the other side was not one of the people who was actually going to be joining our company. It was somebody at the parent company for that organization, and so we were able to, I don't want to say burn bridges, but we were able to be a little bit more forceful with what we wanted. And I think looking at looking at your particular negotiation style, like it really does depend on the type of transaction, I think, and it depends on your leverage as well. Like
Yeah.
if you can walk away and that that's an option for you as a lawyer, you can be really effective. And so, Ashlyn, I know you and I talk about it a lot where, whether it's in a litigation context or whether it's in a contract negotiation context, any negotiation whatsoever is all about moving leverage from one place to the next and exploiting the leverage as best you can to get what's most important for the deal and or for a settlement, in a litigation
Yeah.
context. And so, I think you have to actually develop, several different styles and know when to use them effectively and be able to change in between them, on a pretty fluid basis. And and I honestly, like most of the attorneys that I've worked with, and Ashley, I'd love to get your perspective. Most of the attorneys I've worked with, I've found do that, quite well, right? Um, Although I have had a couple of people go like over the top professional. I just hang up on them, right? Right.
Yeah, I
When
mean,
you
I
just like
think,
give start screaming, it's unprofessional. I'm like, okay, listen, when you calm down, you can call me back. Bye. Right.
yeah, I've had a couple instances where the other side's business team has apologized for how the call went over, many moons ago. But like, you don't want to be that lawyer. Like, I don't want to be, I don't want that to be that lawyer, right? Like, so I definitely think that you have to be a chameleon. Like, you're gonna have to learn your own negotiation style, but your business also informs it. Like, to the point of, if your business is willing to walk over something, that changes your perspective. If this is something that they're not willing to walk over, or like they really need, like, that's going to impact the way you approach in your style as well. And so I think really learning that, and like all of the good negotiation calls you have and the bad are just helping you learn what pieces you can pull. Like, you're never going to be able to mirror someone exactly, but you can pick up tips and tricks along the way.
What, Ashlyn, for you, what do you think are some of the, I guess some of the more challenging negotiating points that you've had to deal with? Like, I'm not specifically talking about like, oh, it's hard to negotiate this like confidentiality provision or right this indemnification provision, but like what negotiation styles have you encountered that you struggle with? like you struggle to like combat, right?
Yeah. I think there's like two that I find really difficult. Like one is when I'm just getting yelled at repeatedly, but like with no substantive response. Like it's just like I'm being told I'm wrong, but like I don't have anything to like respond back to. And the second is just this, we need this because we need it. And I'm like, okay, that's great. I want to work with you and I want to offer something up, but I can't work with I need it because I need it. I need you to help me understand why you need it so I can have the right conversations because we can't agree to what you're asking for. I'm sure we can find a middle ground, but like this just inability to explain the why behind something, I think makes it challenging to move forward. It doesn't necessarily impact the way that I'm going to approach the conversation, but at some point you usually have to get your business partners to step in and be willing to say like, "Hey, we need your help." Like, what is going on here? Like, what is it you really like need from our team so we can convey that and have the right conversations on our side. I don't know. What about you,
Yeah.
Tim?
Yeah, I would echo that. I think, fortunately, I haven't had too many people yell at me in a contract negotiation. It's happened a couple of times, but um, people yell at me in litigation contexts a bunch. But that might just be the nature of litigation attorneys, I think.
Maybe.
So that's definitely one. I would say the other is when I encounter somebody who, as you say, can't articulate the why. I'm less. It's less challenging if they can't articulate the why around from like a business context perspective. It's a lot more challenging, I found, to deal with folks who you understand have, maybe a tenuous grasp on the particular provision
Yeah.
you're negotiating, right? Like I think about it, and not to bury our lead in some of the stuff that we're going to get into a little bit later on, but when you've got people who are challenging you about your express warranty and the interplay of that express warranty with your warranty disclaimers that come up through like a UCC type statute,
Yeah.
like it's really hard to see someone like pulling out fitness for a particular purpose, right? A disclaimer that, warranty fitness for a particular purpose in the context that fitness for a particular purpose is in the express warranty. It's like that's not the way that is intended. That's not the way that operates. That like that's not even it doesn't make sense,
Yeah.
right?
Right.
Like those types of things for me get really really tough because it's hard to, obviously most lawyers have some level of ego, and to tell a lawyer that they don't understand the law is not something that tends toward like a good partnership building path, I guess, for lack of a better way to put it. So like
Yeah.
that's something that for me really just like kind of throws me off my game, and I try to explain it, and a lot of the different panels of things that are more substantive like this, I try to get into some of those provisions and talk about like, okay, this is why it doesn't actually make sense for a data breach provision to be something that's accepted from categorical limitations on damages, right?
Yeah.
Those types of things. So um, anyway, uh, yeah, but the yelling thing is definitely an issue.
I would say to your point on like the legal issues, I like to put it in comments first because it gives folks time to review it. It's a lot easier to have the conversation if they've like had some time to digest versus if you're on the call live being like, oh, I actually don't think that means what you think it means. Or there's this provision of UCC. I do find comments can be really helpful there.
Yeah, and so I apologize, Ashlyn. I actually just lost my audio for a second there, which was bad.
Oh
So
no.
I missed a little bit of what you were saying. Can you do a quick recap for me? Sorry.
Yeah, recap is I like if I'm like providing like warranty disclaimer example, if I want to provide some context on the pushback that I have because it's tied to UCC or whatever, I like to do that in comments before I get on a call. Goes over a lot better if you've put it in a comment, they've digested, you repeat it on a call versus first time you bring it up is live, and it can be a little more challenging to navigate conversations then.
Yeah, you're absolutely right. I mean, there's definitely some value to negotiating through the documents, right, as opposed to being
Yes.
on a call. Um, I know, like particularly with like agreements that are relatively standard, or like our terms of service, for example, for our customers, like it's a pretty plain vanilla down the middle like SaaS agreement, and there's not a whole ton that you need to that that certain customers have particular concerns that aren't accounted for in our terms of service, and it's great, like it's great to have those conversations as opposed to just seeing like a giant block of text, right,
Yeah.
red line text in your document without any context around it. But you're right, like being able to put into the document in advance of a call, like some additional explanation around the provisions, I think is really, and around the edits, is really helpful. Makes the call go more smoothly, and it really focuses the attention as well.
Yeah,
So,
exactly.
um, Ashlyn, which of these do you want to address first? What do you want to talk
Ooh.
about?
Let's talk about IP and confidentiality. Let's go
Okay.
down the middle.
All right. What do you want to talk about first? IP?
Sure, let's go for it. What do you want to talk
All
about?
right. So, obviously, provision that every lawyer should know. Ashlyn, how do you think about, and let's just use, again, we'll use a software as a service licensing agreement as sort of a base use case here. What are some of the IP issues that you want to make sure that you're covering in your agreements?
So I think to start is I really want to understand what is my data versus what is not. And that can get really nuanced depending on how certain SaaS providers have laid it out. And it can be as simple as like this portion of what you upload is, but this portion is not. And it's like slipped in like a little definition on the side. And like if you don't read very carefully, all of a sudden you realize like now they own all of this and you only own like this small piece and you're like, wait, I really care about all that other super sensitive stuff that I'm also uploading. And so I think really making sure you're spending the time to check your definitions and then check the ownership and make sure that you own the stuff that you need to retain ownership into and that you have the right rights and licenses to use anything that you're receiving, whether that's like access to the software or any documentation that they're going to be providing, or if they're giving you any deliverables as well. I think it's really important to have that concept. And if they're building something for you, bespoke or custom, definitely ask those questions of your team, like what are the expectations around that? What is the vendor's expectations, and make sure you understand that as well.
Yeah, absolutely. And I might add just a couple of things on top of that. I think the meets and bounds of the IP license is actually really, really important. And as maybe not for like a pretty simple SaaS agreement, but if you're doing something that's like a more meaningful IP licensing agreement. Like let's say you're doing like a brand sponsorship, right, in a B2C
Yeah.
context, right? Obviously a ton of that at DraftKings. It's like, okay, you know, great, you're granting me a license here to use the New England Patriots logo, but in connection with what? Like,
Yeah.
can I just use it digitally, through whatever channels? Can I put it on, a billboard on, I-93? Can I, what is all of these things happen? Uh,
Yeah. Oh, yeah. I'm sure. I'm sure.
you know, um, and so like really making sure that you have a good understanding of how you're going to be using that IP, if you're the one actually licensing that IP from somebody. Or let's say you're licensing someone's technology, right? Like let's say someone built like a widget tool or something that makes software talk to each other easier or something like that, and you need that to you know maybe you need that to help with some development issues that you're having, right? Like some engineering products like that you're dealing with, or maybe it's a piece of software that you would incorporate into your software that
Yeah.
you then distribute to an end user to use, right? Through a EULA or something like that. It's like, okay, can I, like, am I allowed to do that? Do I then have to put restrictions, downstream on any final end user and their ability to leverage the technology. So I think that's really, really important. And then to the extent that you're building, like if it is software that you're licensing, think about it in the open source context, right? Like
Yeah.
what is yours? What are obligations for things that you build on top of it, or that you build associated with it, or build like as an outcome of it, right? Those types of things, like who owns that, and you know, if you don't own it, can you still use it, or do you need to like now to expand the scope of the license, not just be the thing that you're licensing, but if the licensor is going to own any of the derivatives that you make of it, because you have to make derivatives for it to be effective for you, then you now have to have in the scope of that license your ability to use those derivatives that you otherwise created, right?
Right.
Like those types of things. So it actually starts to get relatively complex. Something that's seemingly simple. It's like, oh, cool, like I'm licensing this, cool. Like when you start really getting into different types of IP, you have a ton of different considerations that you have to keep in the front of mind. How about confidentiality?
Yeah, I mean, I think number one, let's make sure it's in there. That's like definitely
Yeah.
that's definitely a starting point. And like we joke, but there are so many sets of terms that you look at, even for software providers, that don't by default contain confidentiality provisions when you click through and log in. And so I think really understanding that there are some confidentiality protections in there and that you understand what they cover is important. And I think kind of tied in with that, and I don't know if this was intended to be covered under data privacy or not, but like security as well. Oftentimes those can fall into this confidentiality section, or maybe they don't, but make sure that you understand like what is confidential information, how is it going to be used, like what are the purposes for which it can be used, who can have access to it, how are you going to get it returned or deleted at the end, like some of those basics. I think it's a section folks often just can say, oh, confidentiality, like you don't want that to be a check the box section because it doesn't always have all of the things that you need to ensure you're protecting your business and getting line of sight for, what's being done with your data.
Yeah, that's a good point. And I think looking at it in terms of making sure that your confidentiality provisions are consistent with what you're actually trying to protect, right, is
Yeah.
one thing that's interesting. Like when you do talk about like, all right, what is my data and what are the confidentiality? Like, oh, you need to keep my data confidential. Well, depending on how this is written, you may actually end up having a loophole where like because maybe you have shared certain aspects of that data with third parties without restriction on their confidentiality. Now all of a sudden that data is actually not confidential under that carve out in that agreement, right?
Yeah.
So you've got to kind of look at things to make sure that it's consistent. So and a lot of times you'll find stuff is not, right?
Yeah.
Because
A
more
hundred
often
percent.
than more often than not, a lot of the language that you see that's out there is has been around for a really long time, right? Like some law firm from 100 years ago wrote it, and it's just been living in business with modifications here, there, and everywhere for the last century or so, and so like just because it's consistent with a lot of other provisions that you've seen doesn't mean that it's adequate for what you need. So like taking your time on, and I think that goes for really all of the things on the list here. Like be deliberate, read the words, and like understand what these things really mean for you in everyday life. So um
Absolutely.
all right. Ashlyn, what is the next one you want to go through?
Ooh, I will take data privacy and AI for fun.
What what do I need to know? You know more about this than I do.
Oh, I don't know about that, but I think like from a contract perspective, I think one of the things that is interesting that I find, folks often kind of maybe letting this like slip through the cracks a little bit is data privacy does have a lot of protections in your DPA to around security and various commitments that the providers are making from a data privacy perspective. And it's like, great, I have all of these technical and organizational measures, but what if you're only sharing like employees' names and emails, but everything else is like all of your financials and, maybe your company strategy? Like, I don't care so much maybe about my names and my emails going out, but I'm really worried about my entire company finances getting leaked. And so making sure that if there are things in the data privacy terms that are going to um, not be covering all of the data you're sharing, having those pulled over from like a security perspective, like those technical or organizational measures, but also making sure you understand the laws that apply to you. There is, as we often hear, a patchwork. It is changing by the day. I think, we've all had to amend our DPAs, what, like at least 3 times since 2018, if not
Right.
more. And so making sure you understand what the laws are as well, and like can articulate those and vet to make sure that you're meeting those requirements for the data that you're processing, um, I think is key.
Yeah, absolutely. And how about AI?
Yeah, I mean, I think this is an emerging area and an emerging topic. And I think from an AI perspective, just really thinking about like, some of it's all going to interplay with the rest of this, but like, what is your data versus the provider's data? What is the IP rights with respect to like, if it's generative AI, the inputs or the outputs, are they training on your data? Really, again, going back to the fundamentals of like, what is happening with what you're sharing? What are you receiving from them? And like, what rights do you have to do that? Um, I think that we will see over time if we start to get some more standardization in like the language that folks want to use on the AI front. But I don't know about you, but I think that I haven't seen like a totally consistent approach across providers yet on that front.
Yeah, Jonathan and I. So Jonathan is another lawyer on the team here at LinkSquares. Jonathan and I had a pretty lengthy conversation not too horribly long ago um, about what does it mean to own the output of something from generative AI. Like, okay, if I put in prompts to some generative AI and it you know, spits out whatever it does, right? Whatever answer, and now I own it. Well, what does that mean? Really? Does
Yeah.
that then give me the ability to prevent that AI from, given the same prompts, spitting out that same answer again?
Yeah.
Right? Does that then, if I own that output, does that then allow me to prevent other people from using that, like, is more of like a copyright protection where it's like this is now mine, and even if someone independently goes and creates this exact same formation of whatever it was, that I can go and pursue, like, there's a lot of like, okay, what does the ownership really mean, and what are you trying to accomplish? And I would encourage everybody to, on everybody who's listening in, to really think about, like, okay, like, why do you want to own it, and what are you trying to, like, what are you trying to protect, right? Like, if I use like our generative AI, right, it spits out, provisions that you can use in your contracts, right? Like, do I really, like, is it really critically important to me that, like, that formulation of, uh, of a warranty is like something that nobody else can use? Like, no, probably not, right? And
Yeah.
so, like, really think about, like, okay, what is the output going to be, and how important is that for me to own it, right? Because I think the essence of ownership is preventing others from being able to use it,
Right.
right? I mean, like, you think about it, like, do you really own land if anybody can just kind of come on it and do whatever they want with it? Like,
No.
no, like, the essence of ownership is is being able to like prevent people from using what you own, right? And so, when you think about this, like, all right, what's coming out of AI? Like, does it even make sense to own it? And even if you, let's say you do, how are you going to enforce your ownership rights? And against whom,
Yes. I mean, like
right?
the example I love is like, what color is the sky? The sky's going to be blue 100% of the time, ideally. If you asked like an AI assist, like, what color is the sky, right? Like, you can't own the sky is blue as a phrase.
Right.
You can't prohibit that from being output if the person next to you asks the same question. It doesn't make sense. But yeah, I think this is like a nuanced area.
Right. And then you also can't like handicap the AI and be like,
Yeah,
you can't give the same answer twice because the next person is like, what color is the sky? Like the sky is purple, right?
I think
The
it might be
sky.
blue, but I'm not sure. Can't say. I'm prohibited from saying.
Yeah. The sky is the color that when mixed with green makes yellow. Um, or with yellow makes green, right? Whatever.
Yeah.
Yeah. Okay. Where do we go next? What should we do?
Ooh. Do you want to
So
do? Oh, go ahead. You pick.
let's talk. Let's do the key commercial terms. And then maybe because I know we've spent a lot of time on this, and maybe we can burn through a couple of these pretty quickly and
Yeah.
see what we have on the next page here.
Yes. Sounds good.
So yeah, let's start with commercial terms.
All right. What do you want to talk about with them
So,
first? Anything stand
all
out
right,
to you?
yeah. So I mean, this is where my quick 30-second 30-second to 1 minute aspect here is really understand with your business people the things that must be present in order for this deal to be a deal worth doing, right? And be very specific in the way that you're talking about those deliverables, right? If it's if you're buying like some durable good, like is it absolutely essential that that durable good be in your possession on these particular dates? Okay, like then we need to make sure we're building protections around that. Similarly, with like your payment obligations, is it absolutely critical for you? Maybe what you're doing is you have you have some concerns about whether the person you're contracting with is actually going to be able to deliver. So you're going to have payment terms that are carrots effectively for that other party to perform. So it's like really getting at what is essential for your business, like understanding the why behind this deal happening in the first place is absolutely essential. And then be very, very specific with the language. Be like, these are the things that must happen for us to get value out of this relationship.
Yeah, I totally agree. I think like the one thing on commercials that I'd encourage any lawyer to do is not be afraid to advise their business team on them. And we see tons of contracts coming in the door. Like, we might have business requesters who buy one product a year, if that. And they might not know all of the ins and outs of like what price cap negotiations you could have or price like things to think about from that perspective. So don't be afraid to say like, hey, I noticed we didn't do X, Y, or Z. And you've got maybe a 60% discount or whatever. Like, let's talk about that. Let's have a conversation. What is it you're hoping to get from a price cap perception next year? Have you asked for it? Um, just because they say it's all good, check, I've checked it, I feel good with the terms, like make sure that they understand what could happen in the future as well.
Yep, absolutely. Do you want to talk through indemnity real quick?
Yeah, I think indemnity is one of those provisions where I think over my career, like continuing to learn the ins and outs of it. I think like when you're first starting as a lawyer, this is one you really need to dig into and learn, but like it is also one that you will continue to challenge yourself on as you see how it plays out over time, and the way that it can be leveraged. But really quick high level, like third party, you want to make sure you're limiting those to third party claims and really thinking about how this plays into your limitation of liability or other clauses around confidentiality or security obligations or data breach. And really like what is it you're signing up for? Have you actually done something wrong? Do you understand what you might be on the hook for or not?
Yep. Yeah, absolutely. And I think again, like, here's where here's where I think you need to be really, really careful around the language, and you can't just look at like, oh, okay, it's similar to every other indemnification provision. Like, really be deliberate about what you will and will not indemnify the other party for.
Yep.
Um, Limitation of liability. You want to take first crack, or should I?
Go for it.
All right. So when I think about limitation of liability, there's two aspects of it. There's limitation of liability in terms of categorical exclusions of types of damages, right? So, for example, indirect damage is special, consequential, including lost profits, business reputation damage, etc. And then you have like a specific dollarized amount, or under no circumstance will anyone recover any more than 2 times the contract value, or something like that, or 10 times, or 1,000 times, or whatever it is, right? So you have sort of those two those two like aspects of it. And I think the second aspect is pretty straightforward, um, and it makes sense. I think where I see a lot of people pushing back is in trying to accept particular types of provisions from those categorical exclusions. So typically you'll see IP infringement, and you'll see breaches, so breaches of any IP provisions, and breaches of confidentiality be accepted from the limitation that only direct damages are available for recovery in the event of a breach. And the main reason is because proving direct damages in those circumstances is either extremely impractical slash difficult slash impossible, or would also not like actually provide a remedy, right? Like they're
Yeah.
impossible to prove. If you can't prove your damages, you can't recover them, right? Which is why you look at what is the direct damage for a breach of confidentiality, right? It's basically telling somebody some information that is secretive, right? And it's not that they now know this, it's what they do with it.
Yeah.
And arguably that is not a direct damage, right, of that breach. And so when you look at those categorical exclusions, they should be really limited to those types of damages that are impractical slash impossible to prove. And this is where like data breach stuff, particularly for like personally identifiable information, things like that. This is where I personally, I don't think that things like data breach should be accepted from those categorical exclusions, because the damages actually are calculable. They are foreseeable, right? Maybe not the loss of your reputation or lost profits or things like that, right? And that's where people are like, well, that's where the biggest damage is. But in many, many jurisdictions, they have statutory damages for disclosure of personally identifiable information, right? We've got in New Jersey, for example, the damages that you have to provide credit reporting to all impacted individuals for a year. You know how many individuals you have, you know how much credit reporting for a year costs, and that's what you have to do. That's what it is, right? And then you look at like, well, what if I get sued or something like that? Well, then now you look at the indemnification provision. That still shouldn't allow you to go and seek lost profits, right? Like that or loss of business reputation, right? It's not what that provision was intended to do. And I think a lot of lawyers really miss that.
Yeah, and I think too, like when, and I know you and I have talked about this and with Jonathan too, like when you think about it, we all have seen various companies over the years have incidents, and the way that they respond to them and foster that trust impacts their reputational impact as well. So just something to think about as a lawyer as well is like not only should you be thinking about your contracts, but like what are you doing internally to manage and prepare should you have an incident yourself.
That's right. That's right. And then quickly, warranty disclaimers. This is one that we touched on. Maybe we can just recap it if you want to, Ashlyn.
Yeah, so I think, really just understanding like what is it that each party is going to be warranting to each other. There's the usual suspects that you see, maybe compliance with law, the product will conform with documentation, but then what are those disclaimers and how do those interplay together? There are some express disclaimers that you'll see in your warranty disclaimer provision, which are tied to various legal codes like the UCC, for example. And so you just want to make sure you understand how those work together, and just because it is in there does not necessarily mean it's negating, like, for example, your IP indemnity that you have below.
Yeah, exactly. So you think about the disclaimer typically. So you have your express warranty, and typically what you'll see is in your warranty disclaimer, it will actually carve out your express warranty, except
Yeah.
for the warranty in section, ABC, uh, all these other warranties are disclaimed. And the reason is because, as you say, under whatever state's form of UCC is adopted, you have certain warranties that, if not disclaimed, actually are brought in as a matter of law in connection with the sale of goods and services.
Yeah.
So that's intended to have the contract between the parties itself be the thing that really regulates the conduct of the parties and the consequences for failure to comply with the obligations therein. So if you actually are starting to carve out some of those warranties that are disclaimed, you're now introducing a ton of ambiguity into your agreement in terms of how to perform. While it may seem like a great idea, it actually kind of hamstrings the person who's supposed to perform in a particular way or deliver those goods or services. So,
Yep.
all right, more difficult negotiation tactics, and I know we touched on a few of these. Um, Ashlyn, and I also want to welcome anybody if they have any questions. We're running up on time here. We'll cut it off at 3:45 and maybe leave a couple of minutes for questions. But maybe just touch on a couple of these, Ashlyn.
Yeah, I mean, I think that I'm going to start with salespeople and establishing strong partnership, because I think that this is one of the most important relationships that you can build when you're first joining an organization as a legal professional. Is really, if you're working with a sales team, building and fostering that trust between each other, and that's extending beyond each deal. That's really getting to understand like what it is to sit in their shoes and be a sales team member, understanding how they approach their sales cycles, which not only helps you negotiate your deal, but helps you learn really about your product in many ways. You can hear how they pitch it, how they talk about it, allows you to dig in and ask questions, but really showing them that you can help them improve deal velocity, coming to the table with data and providing transparency. If you are going to be pushing back on things, or you can't just like click a button and say, yes, let's sign this immediately, like explain the why behind that. And that really helps build those relationships and that trust, because you want them to come to you. You don't want to be the team that everyone is skirting around to just go do and get the deal done on the side. And without that level of partnership and trust, I think it can be a lot more difficult, particularly when you have those moments where you need to go to your counterparty and say, this is a hard line, sorry. But when they're behind you and they're in your corner, they can really have some of those difficult conversations and help you that middle broker as well.
Yeah, absolutely. I love having the business people who are active in the negotiations, and business people. I worked with obviously a lot of the biz dev folks when we were doing a lot of the sports marketing deals at DraftKings, and after 3 or 4 deals, like a couple of these guys, my buddy Jeremy over at DraftKings. I mean, he's a brilliant guy, and he was able, like, 3 or 4 negotiations with a couple of teams, and he was like already just getting out ahead of the legal arguments too, and
Yeah.
like having him like ride sidecar, and like it spending that time to like help educate your business people on why particular provisions are important and why you think about things in a particular way. Like, they start to become your advocates, and
Yep.
now they're in a position where probably know more about the legal implications of the deal that they're doing than their business counterpart on the other side. So they can almost end around the lawyers altogether to get a lot of stuff done in a business context because it's a business person bringing up this legal issue. So it's now a business issue, right?
Yep.
And so like being able to leverage that is absolutely huge for sure.
Yeah.
Um, I love the saying no. Talk about saying no, Ashlyn.
Well, I don't really love to say no, but I love saying no at the same time. Like,
So satisfying.
it's so satisfying. I mean, it's like, um, there are, if you just say no all the time, no one's going to trust that you actually want to help them. So you can't just be the party of no. Like, no one's going to come to your party. It's not building friends and helping deals go anywhere. But what I do think you can do is instead of saying no, provide solutions, recommendations, and options. So oftentimes, like someone will come to me over the years and say, "Hey, we'd like to do X, Y, or Z," and instead of saying like, "Oh, can't do that," it's like, "Oh, have you thought about this other thing that we could possibly do that I think solves that objective? Maybe we could offer this instead to get over this issue." It makes them feel like you are helping them get what they want and succeed, but not just shutting them down and like making it feel like they're not going to win the deal or whatever it is that they're trying to accomplish. But you need to sometimes just put your foot down and say like, sorry, this is a no go. And if you've built that trust, built those relationships, and they know you're not that, not one that just flows that around willy nilly, they'll understand you mean business when you say sorry. That's a no.
Right. Yeah, and I look at it and I love it and hate saying no all at the same time. Because more often than not when I say it, it's because someone's making an outrageous ask. And it's
Yeah.
just like and I usually go with the approach like, I can't say yes to that, right? Like you fully understand that, right?
Yeah. Yeah.
um,
True.
it's fun.
Yeah.
Obviously, we touched a ton on business needs as a justification. I think one of the ones that I like to use a lot is a straw man, where, I'll know that I can give on something. And a lot of times it's a business point that I like that would be a nice to have that I turn into the entire reason why we're doing the deal.
Yep.
And so that when I give it, I could get a whole lot more for it than just isolating that point like as sort of a, yeah, it's a nice to have. But that I've found that to be really effective. And a lot of times people will recognize that you're doing it right. And like everybody gets it, right? It's kind of like it's just a game, right? Everybody gets it. Okay, like we'll negotiate around this. But if you haven't used a straw man, you should. uh
Yep.
you should.
And those are the things to keep in your back pocket. Like, don't give those up first on the call, even if it's the first item. Make that an issue. You got to escalate. Like, those are good to save to the
It's the
very last
last.
minute. Yeah.
Yeah, it's like one of the last things where it's like, listen, I guess we can do this, but I need these four things, and you need to say like, yeah, I'll take your language on those four things, and okay, cool, and then we're done, right? And
Yeah.
it's like, yeah, okay, like it's got to be like your closer, like this is the line in the sand. We're either signing or we're walking, right?
Yep.
That kind of thing. And I've had it go in directions where, um, we're either signing or walking sort of thing, where like people have walked and we've walked over a straw man, and then that's where you lean on your business person. You say, all right, listen, they called our bluff here. You need to go call them back and just be like, hey, let me get my lawyer in check. Just blame me. But we tried to get right. No deal's done until it's done. Until the business
Yeah.
people say that they're done, no deal is done, right?
Yeah.
So yeah, so you got to be a little careful with that.
You do have to be careful.
What do we have here? All right, thank you. So, Ashlyn, before we get to the sort of closing out, um, any last minute thoughts? pieces of advice, parting words for those who are tuned in here?
No, I mean, I think that like just really developing and leaning into Q4, if this is your Q4 for your company, there is no better time in the year to learn how to improve and enhance your negotiation. It's kind of like the championship games for us as commercial lawyers, and so just lean into that, enjoy it, but make sure you find some time to balance it in January. What about you,
Yeah,
Tim?
absolutely. And you're right. Have fun. I find the negotiation process fun, and at the end of the day, you get deals done. And who doesn't like to close a deal, right? Closing a deal is like one of the best feelings ever. It's so even the small ones, you celebrate them. So
Mhm.
enjoy it, have fun, and for those listening, reach out to Ashlyn or I anytime if you want to talk about any of this stuff a little bit more. We love to hear from you all. I'm Tim at LinkSquares.com. Ashlyn's A Donohue at LinkSquares.com. Send us an email. But thank you so much for joining. Those of you, I believe we've got a virtual networking event at 4 o'clock, so you should have a link in your inbox. If you didn't, as it says here, just send an email to events@linksquares.com. And thank you all for joining. And Kristen, is there anything I missed?
Nope, that's all, Tim. And just want to remind everyone that there will be a survey sent out in the next 48 hours about the event. And if you need CLE credit, there's some information in there that you should just check it out. And there's a form you'll need to fill out to actually submit for the credit. So your feedback is very valuable, and we're always striving to create beneficial content for everyone. So we appreciate it. Thank you.
Awesome. And Ashlyn, thank you so much for jumping on this and keeping me company so it wasn't just me droning on for an hour.
Well, thanks for having me, Tim.
Thanks. All right. Take care, y'all.
Thanks. Bye.